now in session. Honorable Elizabeth Shea presiding. Be seated and remain quiet, please.
Okay, we're here on the case of the state of Florida versus Nikolas Cruz. Are all of the attorneys present?
Yes, Your Honor. Blakey Vandell on behalf of the state, Your Honor.
Melissa McNeil, I'm sorry,
Sherry Tate on behalf of the state.
Melissa McNeil on behalf of the
also present, please.
I'm sorry?
I said the defendant is also present, is that
Yes,
correct?
Mr. Cruz is present, Melissa McNeil on his behalf. Diane Cuddy, Mr. Cruz's behalf.
All right, let me start off by saying that although I didn't consider any of these matters to be confidential, an order has been entered on Friday by Judge Rivolo. I have reviewed these materials thoroughly, and they deal solely with the public defender's office having access to their own client's person while in the Broward County Jail. I don't believe that the state has suffered any prejudice by these matters being kept confidential, and I am going to leave everything the way it is with the caveat that in the future, going forward, all matters in this case are going to be heard by this court, and if there is a motion to keep something confidential, the motion, at the very least, is going to be heard by this court in the presence of all of the lawyers and the defendant. Does anyone have any questions?
Judge, are you keeping those orders under seal?
An order has already been entered. Again, I believe I made it clear on Friday that I didn't feel it should be confidential, and I said it for today. But what's done is done. Again, it deals solely with the public defender's access or the defense's access to their own client's person, which, had the state been noticed, I don't think the state would have had any objection or any standing to object to them accessing their own client. Because the issue is so very limited, as far as I can tell, I'm going to leave it the way it is. And just, again, I have a copy of the administrative order for each of you so that you know in the future the matters are going to be heard by this court in Division F, Judge.
Judge, the only issue is that the state, pursuant to the case law as well as the rules, believe that whatever motions were filed by the defense should be accessible to both the state and to all parties. It is part of a court proceeding. I have found some case law that's directly on point that the defense is not entitled to conduct any type of discovery in secret. They did make a request, which was granted at magistrate court, to have access to their client for purposes of photographing him. The magistrate judge had no problem, but it is the state's position that whatever the court is in possession of as way as motions should be unsealed. Now, if you want the state to file a written motion unsealing it, we can certainly do that, but we are prepared today to argue why it should not be under seal.
I don't disagree with you. However, I just feel that because an order has already been issued by this court, meaning a judge in the 17th Circuit, that and because, like I said, it's a very limited issue. I believe the defense was entitled to what they were asking for, and this court has already ordered that the motions and the order be sealed. I'm going to just leave it the way it is.
Okay, we'll file the appropriate paperwork. Thank you.
Ms. McNeil, did you want to say anything more?
Nothing at this time. Thank
All right,
you, Your Honor.
thank you.
Your Honor, would you be able to prepare a written order that reflects?
Sure.
Thank you.
This is a pool situation out here. This is the pool camera.
Okay,
All right?
no problem.
Thank you.